Greetings, this is Rob Chassner, and the purpose of this video is to train anyone who wants to do the follow-up documents to clear up the public side of a set-off with an alleged creditor. Everything that's said and expressed here is for educational purposes only and document resources only, and is not to be considered as advice in any capacity at all. And you're watching this and using any of these materials constitutes your consent and agreement that I, Rob Chassner, and Rob Chassner Consulting are not giving you any form of advice in any capacity. I'm not representing you or in any fiduciary role, but merely providing educational material to be used at your own risk and document resources to be used at your own risk. Okay, so I'm going to refer to the first document, which is called a Notice of Tender for Setoff. Notice of Tender for Setoff. And there you go. And so if you're opening up that document, this particular one was used for an offer of obligation with a hospital bill. It's the very same document that I would use for the same purpose for any offer of obligation, whether it be the Internal Revenue Service, a mortgage, a car note, credit card, collection agency, whatever, any obligation. An obligation is an obligation offer, and if you've done a set-off package in equity on the private side, in my opinion, and this is what I do, I would establish a zero balance on the public side with the alleged creditor. So I'm going to go over this document in its entirety. So again, your first title here is Notice of Tender for Setoff. The claimant, that would be the party who made the tender. You can see it's labeled as upper lowercase as authorized agent for the all capital letter name. The respondents, I use upper lowercase acting as the all capital letter name, and then the party's position with the alleged creditor, agent for the alleged creditor, and any agent, successors, and or assigns. And then if there's other parties, you would list them in the same fashion, or you could just put all agents for that particular alleged creditor. In this case, I added the 3 credit bureaus because oftentimes the banks and the alleged creditors at large like to use this kind of a tactic to force you into submission by messing up your credit. So you can make the credit bureaus equally liable. I also put John Doe's 1 through 50 in case somebody attempts to intervene. I will name them as John Doe 1 and so forth and so on. Anyone who interferes with my right to a remedy in commerce. And then I put jointly, severally, corporately, and personally. Sent this one by certified mail. It's in reference to, and then of course you could put what the alleged obligation that they're offering you. So attention respondents, and essentially what it's saying here is, whereas the tender for the set-off for this account has been submitted or presented to whomever the tender agent was that you set this off with in the private side. In this case, I used Ursula Gillis, CFO and agent for the Internal Revenue Service, and then further going on. And whereas the tender for this account in the amount of whatever it was, so there was 2 obligations here, so I listed them both. And whereas the tender was accepted, Now I cited, because this is the public side, I cited some of the UCC laws. And the evidence that it was accepted is your affidavit of non-response from the tender package. In other words, if they don't send it back to you, they've accepted it. All right, so therefore, then it's referencing me as the claimant, requests that the accounts be adjusted to zero balance, and that you're enclosing, or I'm enclosing, a request regarding a statement of account. And we'll get to that later on in this particular document. And then we give terms on how they are to comply with this request. I've given them 10 days, and if the request of the statement of account is not correct, you're giving them a chance in 10 days to sign their own affidavit to say that it's wrong. And if they don't, that you're going to memorialize their non-response with an affidavit of non-response. And if they don't adjust the public record to zero, you're going to memorialize that with an affidavit of non-performance. And upon the respondent's acceptance, so the acceptance would be that they don't respond in an affidavit format, then they're accepting your zero balance. You're then demanding that they rescind any defaults, collection notices, negative credit reporting, new offers of obligations, and so forth and so on, and to execute or cause to execute a notice of zero balance in the public record, including but not limited to the credit bureaus. And it says in the next paragraph on the next page, this would be page 3 of this document, if they don't respond, if they fail to execute or cause to execute a zero balance in the public record within the 10 days, that shall constitute that they are granting you, the claimant, specific power of attorney to do it on their behalf. So respondents shall give the notice of a zero balance for the collateral by mailing to the claimant within 10 days. Now, this would be a paragraph if it was a mortgage. You would also demand in there that they release the lien in the property records, reconvey title in the property records, and to terminate the trust which holds the alleged mortgage that's in the property records. And that if they don't do that, then they're granting you specific power of attorney to sign on their behalf. And then you're giving them instructions that any and all responses are to be sent directly to you. And again, it must be done in an affidavit format swearing under penalty of perjury with full and unlimited commercial liability. And then I go ahead and execute and sign and so forth. And you can see under the signature line that it's the same as, all the private citizenship stuff that we've done in the past, that I am signing as an authorized agent and sole beneficiary of the trust known as my all capital letter name. So that's really who all of these obligations are being offered to, is that corporate fiction, the all capital letter name. And you can see that on the next page that I've put a notary box for the notary to sign. Now the next page, on page 5, would be the statement of account. And again, it's very self-explanatory. You're sending it to the people who are that are representing the alleged creditor. It's regarding those particular offers of obligation, and then you're putting in there that the balance of those accounts is zero. Now, if it's an unsecured line of credit or something like an IRS debt or a credit card, then the collateral listed would be your all capital letter name. If it's a mortgage, then you would put the collateral, which would be the legal description and the address of the property. All right, on the next page, showing the balance due of zero, and you're signing that as an affidavit, so there's another notary box there. And And then I like to, on that 7th page, the record of tender, I like to list how many pages and what was in the record of tender and send copies with the notice of tender for Setoff. Now, if you've already sent that in another document, it'd be okay not to send it again, but I like to send copies of all of the things that were sent for the presentment of the Setoff package. All right, so that covers the first document, which is referenced there as 2.2. Now, they're not going to sufficiently respond. We all know that. They're not going to swear under penalty of perjury that you owe them money. They'll offer you another obligation. They'll just act as though you still owe the money, but nevertheless, if they don't send it back in an affidavit format signed by a real party representing that alleged creditor, then when those 10 days are up from the date that they received it, and of course, you want to print out USPS.com, that registered or certified mail number. You want to print out it showing when it was actually delivered, that document, the first package. So you would prepare an affidavit of non-performance. In other words, if they didn't mark the public record to 0, or if they didn't cancel the mortgage or whatever the case may be that you demanded, you do an affidavit of non-performance. That is document 2.1. And obviously, if they don't respond with an affidavit swearing under penalty of perjury, you would execute document 2.2. Those are easy and self-explanatory. And at the same time that you do the non-performance and the non-response for the notice of tender for Setoff and the statement of account, you would then want to go ahead and prepare on the same date as those non-response and non-performance affidavits the next document, which is called the 3.3 document. And we'll go over that in detail now. Essentially, you're giving them a second chance to respond according to the demands that you've made. So you can see again, it's the claimant and the respondents are the same. Now, if there was a third-party intervener like an attorney or another collection party or something, you would want to send them a notice that they've been added as John Doe 1 or John Doe 2, and you'd want to add them to this package and every package thereafter until you've got your zero balance confirmed with their non-response. So now we'll get to the next page is, again, the reference would be the offer of obligation, and now you see the statement of facts. And essentially you're saying on such and such a date, we sent evidence of a tender package. It was received through the mail on such and such a date. We sent a request regarding statement of account and demanding that they respond and perform, and how to respond and perform with an affidavit. And then you can see in number 4, the respondent's failure to perform constitutes their acceptance and approval of granting the claimant specific power of attorney to perform those responsibilities or duties on behalf of the respondent that was stipulated there, and the respondents are at fault, and as an operation of law, the respondent's dishonor created a fault. Now you're giving them a second chance, so you give them 10 more days, opportunity to cure. Now those 10-day periods were selected by me. You can give them 30 days, 15 days, 14 days, 10 days, and even 7 days or 3 days. Under 3 days, you know, that's what under truth in lending they do. So if you're dealing with a bank that's really nasty, you might want to consider giving them 3 days to respond. But again, you have to take the position, you know, what if you were wearing that big black robe and sitting on the bench? How would you view you as the claimant? Did you give the respondent sufficient time to answer? So you want to make sure that you're showing yourself to be fair and equitable. So you give them another 10 days, let's say here, and what are you giving them? You're giving them 10 days to either correct your statement of account, that was the affidavit of zero balance, or if they don't correct it, then mark the public record, to zero balance and to notify the credit bureaus, or to execute or cause to execute an updated statement of account showing paid as agreed, and if it's a real estate deal, you'd want to, demand that they reconvey title, cancel the lien, and cancel the trust that's holding the alleged mortgage. And so you're giving them a second chance there. And the sender response, again, you tell them where to send it to, and you sign it and date it. And on the next page, you can see I've done this in front of a notary, and then I do enclosures. Again, a list of all the different things that you want to enclose. All right, so that concludes the notice of fault, opportunity to cure. Now, on this particular document, before we close it down, there are many things, like in the paragraph right before, where it says, right before where you're showing them where to mail to the claimant. So this would be the top of page 3. After the number 3, so you can see the paragraph, failure to cure will constitute as an operation of law the final admission of the facts set forth in the presentment by respondent to a tacit assent to the presentment, and the whole matter shall be deemed res judicata in stare decisis. That's Latin for final judgment, and that it is adjudicated. But you could also add a paragraph in there. You can say, and constitutes your agreement and consent to the following, and you can put a long list of things. Now, many of you that are watching this would have other documents that have that kind of verbiage in it, like the offer and or notice and demand document, sets of documents. You can say that your consent and agreement to a zero balance, your consent and agreement that any further action in this matter, including collection calls or new offers of obligation or negative credit reporting, will be subject to a $10,000 or whatever number you want to put in there, fee and fine upon demand by the claimant, and your agreement to pay it, and your agreement to or consent to liens or garnishments or that kind of thing for your personal and real property and personal property, corporate property, personal property, that kind of thing. So you can make that list as long as you like, but that's where it would go, would be if you want to demand any of those things. All right. So when they don't respond sufficiently, you would go back to those 2.1, 2.2 documents and edit those. That's the affidavit of non-response and affidavit of non-performance, and just say that they did not respond to the notice of fault, opportunity to cure, and that would satisfy that that affidavit that they did not respond or did not perform. Now, the final document is the notice of default and consent to judgment. Same titles, claimant, respondents, and so forth, all agents, credit bureaus, John Does, reference, and all that. And then the statement of facts just covers all that you've done up until through the notice of fault, opportunity to cure, and then you've got the paragraph that that the default failure to honor these presentments and the fault notice places the respondent in default, and for the course of dealing set forth herein with the respondent's failure, refusal, or neglect. So essentially, they're saying that that this is now res judicata in stare decisis, or a final judgment that they're agreeing to. You could also add in there, if you added anything in the notice of fault, such as your consent to a $10,000 fine or fee for each and every time you offer a new obligation or a collection call or negative credit reporting, that they're agreeing to pay you upon demand that $10,000 per incident, that kind of thing. That would go right there, and to govern yourselves accordingly. And this is the final expression of the record, and then you sign it, and there's a notary box there, and I also put enclosures there. So there you have it. After that is complete, Now, you'd probably would want to add a notice of estoppel, and that can be a separate training session on the notice of estoppel, because you can do an estoppel on the private side and you can do an estoppel on the public side, but that would be something you would likely want to do. Now, when it comes to mortgages, as an example, it's a little bit more tricky, because you've got this lien in favor of the alleged mortgage holder filed in the real estate records. You've got so the title is bound up by that, and there's a lien against the property, and there's a trust that holds the mortgage. And so in these documents, if it's a mortgage, you want to specifically list that their non-response constitutes their consent and agreement to granting you specific power of attorney to mark the public record to zero balance, and to release the collateral. And you can express that any way you want, but I like to say you're granting me a power of attorney to sign on your behalf to mark the public record by reconveying title, canceling the lien, and also to terminating the trust which holds the mortgage in the public record. That gives you consent and by them to sign those documents on their behalf to mark the public record. In other words, they're not refuting your zero affidavit through an affidavit of their own, and their non-response constitutes their agreement to grant you power of attorney. So then you could take and create the documents that would be necessary to release the lien, reconvey title, and cancel the mortgage trust that's in the property records in the public, and sign on their behalf. So those are a little bit tricky as far as how to do those, and it's different in every county and every state. So when you get to that point, you would likely want to find other documents that banks used to release the lien, reconvey title, and cancel the mortgage trust, and use those in that county where the property is to conform with what has worked in the past, so that the documents look proper and appropriate, and they're done correctly to satisfy the recorder's office. All right, I hope this has been helpful and informative, and if you have any questions on any of those documents, feel free to contact me. You have my information. Thank you and good day.